everybody. This is Greg DeSimone. Welcome back to this month's episode of DeSimone and Deals, the Exit Strategy Podcast. And as always, we bring on different guests that can help business owners better prepare for their eventual exit and help maximize value and de-risk their business and eliminate a lot of headaches that may come up during that process. In that vein, I've actually brought an attorney on that I've worked with over the years. I've known through networking circles and have done work with him. He actually has given me advice on some of my employment contracts with some of my contractors and employees. So I trust him implicitly. His name is Tim Foley. He's a partner at Foley & Foley, attorneys at law. He is an employment attorney. He specializes in all kinds of issues, whether it's non-competes, employee handbooks, make sure you're in compliance with different rules as different state laws come up and rules change. Tim has helped his employees stay ahead of the curve and out of trouble, and in most cases helped his clients get through their transactions in a seamless manner because they were prepared. So hopefully I did a good job explaining what you do, Tim, but why don't you fill in the blanks of what I missed?
Sure. Been a practicing lawyer in Massachusetts for a little over 32 years. I'm also licensed in Pennsylvania and Kentucky. Our firm has a national practice, and we focus primarily on management side, employment law, and labor law. But also, as you mentioned, do a lot of transactional work representing companies in uh, buy-sell arrangements, asset purchases, and also any kind of contracts, really. So, been doing that for a long time, and it's a part of the job that I really enjoy.
Excellent. So, and to Tim's point, he does more than just employment law. He actually does it in the context of transactions and or helping partnerships and closely held businesses document their company, document their operating agreements in their employment agreements to help for seamless transitions, whether it's through a sale, generational transfer, or a management or partner buyout. So, in line with what the podcast is helping business owners get prepared for sale and de-risking their business. If you were talking to your client and they said, "Hey, I am thinking about selling in the next 3 years," what are some of the things that you would start talking to them about to make sure that they had lined up and documented if they weren't already done so?
Sure. Obviously, you want to make sure that you have limited your risk of litigation because selling a business with pending or potential litigation is going to negatively impact your ability to sell and or the price. So first thing I would do is I would conduct an audit of my wage and hour practices and ensure that I have everything legally in place as far as I'm paying my workers correctly. And if I haven't paid them correctly, I would take steps to rectify that situation. I would potentially voluntarily pay employees unpaid wages, things of that nature. In addition, I would have my contracts. If I have contract employees, I would have my
Can I stop for 1
contracts.
second?
Sure, of course.
So,
Yes.
on an audit for wage and employment practices and wage and hour practices, if you haven't paid them correctly, what are some of the examples of an employer not paying their employees correctly?
Sure. A lot of employers don't pay overtime correctly. So, for example, if you have an employee who has multiple rates of pay, this happens a lot in construction. Somebody has a regular hourly rate, then they get prevailing wage. You have to properly calculate the overtime rate based upon the two different rates or several different rates at times. There's typically a blended rate for overtime, and a lot of employers don't properly calculate that, or they try to pay the overtime rate at the rate of the work that's being performed, and that is incorrect. So we see a lot of overtime mistakes. With misclassification of employees, we see a lot of failure to pay overtime. People identify employees as exempt from overtime incorrectly, and they're not paying them overtime. They pay them a flat salary, and if if these people work over 40 hours in a week and they're not paid additional money, that's a wage and hour violation. Um, it's identifying who's a an exempt employee is difficult. The law presumes that people are hourly and entitled to minimum wage. So, as an employee, you have to meet a fairly strict test to show that these people are, in fact, exempt from overtime. And it's not always easy. So, a lot of employers run afoul of uh, the law in regard to exemption and then don't pay overtime properly.
So a lot of times I've heard employers say, and actually it's not really clients of mine, it's just people just know from around town or golfing, and they talk about how they do things and how they're pulling one over. How does this show up, and how does it during a transaction, and when you're trying to transfer the business, and what does it do to the transaction? What are the negative outcomes or adverse outcomes that could happen?
So,
Like you
when
didn't pay overtime correctly. You thought you were pulling one over because you weren't doing it correctly, and you were saving a little bit of money. How does that show up during the process, and what's the negative impact it could have?
Sure. So if I'm the buyer's attorney, I'm going to want to know how you classify all your workers. I'm going to want to know how you've paid all your workers because there's a 3 year, well, sometimes it's a 2 year, but it's up to a 3 year statute of limitations on wage claims. So uh, I could be buying into a claim that it exists for several years, and I could be buying into a circumstance where employees believe that they're in a certain classification, that they are paid a certain way. And if I come in and I completely change things, they're going to get upset. So it's really important when you're the attorney and or the buyer doing due diligence that you figure out, well, how are they paying these people and how do they classify them? And are we buying into a lawsuit related to the wage and hour history? And if we are, then we need to make sure that the seller's indemnifying the buyer for past wage issues. And we also need to figure a way to reclassify workers and pay them correctly.
So what you've seen, and some of this is going to sound like I don't know what I'm talking about, but I'm trying to set you up to answer these. Um, so a buyer, when they come in, even though you've been doing it a certain way, if it's not correct, they're not gonna take the risk and hope they don't get caught. They're going to most likely say, "Yeah, we know how you did it. This is how it needs to be done. Here's what the financial impact that you have to cover because someone could come back and sue us for underpaid wages." Is that correct?
Absolutely. If I'm the buyer, I'm going to want the seller to cover all potential um, losses related to any claims that the buyer, I mean, the seller created during their ownership, and one of those is wage and hour claims. And the problem with wage and hour claims, particularly if it's in Massachusetts, is the the Wage Act trebles wage violations. So if I'm committing wage violations, say it's $50,000 of wage violations, that's actually $150,000 of wage violations plus attorney's fees for the people that seek to collect it. So that claim can escalate dramatically and quickly. And so as a seller, I'm going to want to make sure that I straighten all that out in advance, that I appease my employees if any of them are disgruntled about wages, and clean up my situation before I sell so that I'm not selling a business that is potentially going to get sued for wage and hour violations.
So is it fair to say that if you're planning on selling your business, your known outcome is a third party sale? Either you're going to pay the wages by doing it correctly, or you're going to pay it as part of an adjustment to the purchase price when you go through diligence to the close. Is that a fair statement?
Yeah, but you may pay more. as part of the sale, because of the significant downside to a claim.
Correct.
Whereas if you correct it in advance, you can pay single damages,
Hmm.
and there are ways to message it that will keep the employees happy, and avoid claims.
So, I, and I keep going down deeper and deeper in this, but this comes up a lot, and I want to make sure people are very clear on what they need to do here. Um, Sometimes I hear an owner say, "Well, it's going to be it's a stock sale, so like the liabilities don't transfer over. Why do I care? Why would a business owner care if it's a stock sale versus an asset sale?" And for the people who aren't familiar, stock sale means when you buy the company, the new buyer buys the company. They're buying the certificate and they buy the company as is, and all the past liabilities come forward. Um, but if you're doing an asset sale, technically all the employees get terminated, all the assets gets transferred from your company, and they move to a new company. So theoretically, liabilities don't transfer. But why is it still important whether it's an asset sale or a stock sale?
Because you're gonna, as the seller, you're gonna be keeping that liability regardless. And so again, if you sell and you sell at a certain price and then you subsequently get sued for wage and hour violations, and they're seeking treble damages and attorney's fees, that's eating into the profit that you got from your sale. And it's better to, like I said, resolve it at single damages, meaning correct your payment mistakes and get some kind of an agreement with your employees in place, um, before you get sued by an attorney representing the employees for treble damages. And that's going to happen more likely too if you have an asset sale and you're terminating the employees and they don't all get picked up by the new company. They're going to be disgruntled, and if they have claims, they're going to pursue them. And wage claims are a big money maker for attorneys these days. So you're likely to face a plaintiff attorney that's looking for that kind of a claim.
And related to this wage and hour compliance, I think you touched upon it a little bit, is your classification of independent contractors versus employees. So you have exempt, non-exempt, like are they salaried or are they qualify for overtime? Um, and then you have independent contractors and W-2 employees. How important is that going through that review process leading into a sale?
It's significantly important because of liability. If you misclassify an employee as an independent contractor, you're not paying employment taxes, you're not paying into the unemployment system, you're not paying paid family medical leave, you don't have workers' comp for that worker. And so there's a lot of expense that isn't being paid by the business that could could be part of damages in a claim for misclassification of the worker. The way those cases typically come up is the worker gets hurt, they file for workers' comp, they find out that they were not covered by your workers' comp, they don't have their own workers' comp policy, they are not going to be covered by your workers' comp insurance, so they pursue you individually as an organization for all their damages related to their injuries. So you could face that kind of a claim. Um, in addition, a lot of independent contractors are paid a flat amount of money, like a flat weekly amount or a flat monthly amount, and there's no tracking of hours. So if they were misclassified as an independent contractor, they were not tracking their time. They'll come in and say that they were working 60, 70 hours a week for you. You're exposed then to potential overtime claims. And again, we're back to the overtime, treble damages, attorney's fees exposure. So, that the failure to properly classify an employee can have dramatic effect on the value of a business, the exposure that you face either before or after the sale, and you want to rectify that as soon as possible before you start trying to sell your business so that the value of your business is maximized.
I think this is a big point for people to understand is if you're not properly paying your employees a class, they're not classifying them correctly and they're not properly paid. When you go through diligence, and I'm sure Tim, you can confirm this, they're going to identify those differences. They're going to say, well, you know what? This is what the expense should have been if you were doing it correctly. So you thought you were making $1 million. You're really not. You're making 900,000. So where you're not going to get the benefit of showing the higher profit because you were misclassifying. It's going to get level set and treated. Not only that, they're going to say there's a risk and exposure where someone could come back and we are not going to pay for your past sins. So we're going to have an indemnification or potential and most likely an escrow, have you escrow funds or hold back funds until the statute of limitations passes so that they don't come out of pocket for any of your past errors. So a lot of times and tell me if you see this as an excuse that say, well, I don't want to, I'll let someone else take over my problem. My problem. I want to maximize the value now. And in theory, what they think that works. And what really happens is they get dinged for it two ways. The normalization of their earnings and a holdback on potential liabilities that could come back in the next 3 years.
Yeah, and I think we go back to the stock sale, asset sale situation. In a stock sale, you're going to want a significant reduction in the price because if you haven't had people on workers' comp and you haven't paid all these taxes and whatnot to the system, that person who's buying the stock of your business is stepping into your shoes and is exposed to all that. So they're going to want a significant reduction in a stock sale. In an asset sale, all of those exposures remain with you. You're still on the hook for them, and there's a 3-year statute of limitations for misclassification that you could face. Again, claims from former employees who are let go that want to get either overtime or want to collect something from you, like some of the benefits that you didn't pay them when you were treating them as independent contractors. I think the other thing that's really significant for employers to know, Massachusetts has a very strict independent contractor statute, one of the strictest in the country, but every state has an independent contractor law, and they're not easy to pass if the person is working for your business and doing what your business does. And so you really have to look at the law or the jurisdiction where you are and figure out, is this person truly independent from us or not? And because that's the audit that the buyer is going to do, or the buyer's attorney is going to do when they come to look at your business. That should be done in advance by the seller.
So we've gone really deep on the wage and hour compliance with the independent contractor classification. What are some other things that they should start thinking about 3 years in advance?
So confidentiality and other restrictive covenants, you want to look at them. If you don't have them in place, you might want to put them in place.
How would you put them in place? Is it like through an agreement or is it through your handbook or how do you do that?
So I mean, I think it depends on a lot of times the position. So certain senior high level people, you want to have a written agreement that they execute. You typically are going to give them some benefit to bind the agreement, whether it's continued employment or something additional above continued employment. And that can be jurisdictionally based. Some jurisdictions allow you to use continued employment as consideration for a restrictive covenant agreement, like a non-solicitation or non-compete or a confidentiality. But some jurisdictions require you to give additional consideration. So you need to know what the law is of each state in which you're operating. But with regular, I'd say line employees or lower level employees, having a confidentiality policy in a handbook that they've signed off on is always important, step to protecting the either the IP or the proprietary information of the business. So your business is more attractive to a buyer if you've protected those assets that they're going to want to buy. And if they're fearful that the person's going to leave, after you sell and just take it or disseminate it to other entities that they're competing with, the business will have less value. So you want to put in place really strong agreements with the people that can easily hurt your business, like leadership, maybe salespeople.
Hmm.
But then like I said, with the other employees, you just want to have them sign off on confidentiality so they're not, you know, um, disseminating information without thinking about it.
So you made a reference to the non-competes, and I know the laws have changed significantly over the years, particularly in Massachusetts and the East Coast and the West Coast, where I think are a little bit more onerous than, say, the Midwest. Um, can I give a quick overview? Why don't we focus on Massachusetts because I think it's one of the more strict. And what are some of the rules and how does a company, knowing that they can't, based on the rules that are the strict rules that they have for non-competes, how does a company still protect themselves against employees leaving and harming their business?
So, the primary way to protect your business is to protect your proprietary and confidential information. And again, that's done through non-disclosure agreements, meaning confidentiality agreements, or non-solicitation type agreements. So the courts are much more willing to enforce an agreement that is designed to protect your confidential and proprietary information and your trade secrets than they are to prevent somebody from going to work somewhere else. You can still in Massachusetts have a 1 year non-compete agreement. Um, they're still legal as long as you comply with the strict provisions of the law in Massachusetts, which require that you provide compensation, and you can only have the agreements with high-level workers. So there's a lot of very uh, stringent provisions in the Massachusetts non non-competition statute. What we've been recommending to our clients is that they focus more on the non-solicitation, confidentiality, non-disclosure type agreements, uh, and work to protect their confidential information, proprietary information, rather than trying to prevent somebody from going to work at a competitor. Um, so I would recommend that somebody who's trying to sell their business put in place restrictive covenants like I've been talking about with the senior level people and salespeople, but that they focus mostly on prevention of the dissemination or taking of their confidential and proprietary information.
So any other key um, items that they should be focusing on, what, 3 years in advance?
Um,
Like handbooks, is handbooks a big issue? Like sometimes I see clients they don't have a handbook. How important do you think is having a handbook in place through a process like this?
so we're a big proponent of handbooks because the best workplaces have clear, succinct legal policies, and they enforce them. So when you see a company with a good handbook that's been enforced, like they have good discipline records and they have regular training, and you as a buyer can feel pretty confident that you're buying into a well-run machine. Whereas if the business doesn't have a clear and concise handbook and good policies and doesn't train and doesn't enforce its policies, the risk of claims and chaos is much higher. And so, if you don't have a handbook or you haven't updated it in a few years, it's critical that you do that, particularly in advance of a potential sale, because you want to put your best face on when you're trying to market your business. And one of the best ways to do that is to show that you're organized, that your uh, business is in a position that is well maintained, and your staff is trained and they are compliant with laws. And having good policies is a great way to put your best foot forward.
One of the issues that comes up a lot um, is immigration issues. And I've had clients, prospects that I've never engaged with because they just refused to comply. They said they couldn't compete unless they paid people under the table or they had to actually get them properly documented. What is your advice with clients on how to handle immigration issues and the proper documentation of their employees?
Yeah, well, we see this one a lot, really. And the law that you're dealing with is I-9. Um, and basically, you have to fill out, as you may know, at the start of somebody's employment, within 3 days of their start date, they have to provide you with documentation that complies with I-9 and fill out the I-9 form. And if you don't do that properly, you can hire individuals who are not legally authorized to work in the United States. And we've had a lot of clients, unfortunately, that have come to us because they're being audited by the federal government for their I-9 compliance. And oftentimes they don't have the proper paperwork in place, meaning the forms aren't filled out correctly, or they didn't check proper identification, and they can face significant fines associated with each mistake, each I-9 form error. So, again, looking at the 3-year window that we're talking about, having an I-9 audit is always a great idea, particularly if you're going to be doing a stock sale, because the buyer is going to be taking on your employees. And whenever a buyer is taking on your employees, they're going to want to look at your I-9 forms to make sure that everything is in place. And so if you don't make sure in advance that it's in place, you're going to have a lot of explaining to do to potential buyers. If they find out that you don't have forms, you don't have documents, you potentially have people who aren't legal. When you hire people that aren't legally authorized to work in the United States, that's a violation of the law. That's potentially criminal, for one, and for two, obviously, like I said, you can face fines. But you can also lose your staff, right? People are getting scooped up off the street right now regularly because they're not legally authorized to be here, and they're getting removed from the country. Well, if you hire people that aren't legally authorized to work in the country, you could lose portions of your staff on no notice, and
Hmm.
and be in a situation where you're shorthanded, or you can't meet a deadline, or you can't uh, accomplish what you promised a client that you'd be promising. So I I always try to recommend to clients that they hire people who are legally authorized to work in the
Hmm.
country, meaning they properly check I-9 paperwork and fill out the forms correctly and store them correctly. But you're right. We have a lot of clients that are in the trades, and sometimes they say that they can't comply, and I tell them, well, all right, there's a risk with that. You risk, like I said, government audit, fines. Uh, but in this context, you risk the possibility that somebody's not going to want to buy your business, or at least not pay you the price that you're looking for because you haven't complied with the law for a period of time.
Yeah, that's a good point. Like one thing you said is if there's an audit, what would I want to touch on that first thing and come back to the price you're talking about. What would trigger an audit? Is it just random or is it someone dropping a dime or how does that work?
So most of the time, because the government's resources are limited, they're not random audits. Now, random audits do happen. They happen in certain specific industries more than others, like restaurant, construction, but they're not as common because of the resources issue. What typically happens is your employer, you're paying taxes like Social Security and such to the government on a certain Social Security number under a certain name, and it's not matching at the government level. They they flag it, and then the next thing you know, you get a visit because your the Social Security number that you're paying on doesn't exist or doesn't match the name that you're paying under. So that's one way. Another way is um, that you get um, reported, right? Someone competitor or some uh, disgruntled former worker, some
Who
you
may have lost a
terminate
job to it or
somebody,
so they lost a job to a lower wage person.
right?
And, okay.
Right. They report you, and that's happening more frequently lately because they know that the federal government right now is very eager to find people who aren't legally authorized to be in the country. And if you're retaining, if you're hiring and keeping these people as employees, you might be aggravating some citizens who think that you shouldn't be employing those people. So, yeah.
And you mentioned about the affecting the deal price, and I think that's another key issue where you talk about being, and this is the language I hear from the prospects that I typically don't bring on as clients. So, well, I can't be competitive. I have to pay higher wages. Well, what have you seen? I think I see where the buyers come in and say, okay, yeah, these people are not legal. We're gonna have to get them either into the system, which means we're gonna have to pay them higher wages, or we're gonna have to replace them and train someone new at the higher wages, which means you're again, let's use that $1 million profit. Your $1 million profit using under the table labor or below market labor because they're not legal. Now is no longer a cost advantage. You actually have to let the level set it during diligence. Say, here's what it's really going to cost, and here's what it's going to cost because these we have to hire new people and they're not trained. And so now you're a 900,000 or $800,000 profit company, not $1 million company, and your valuation get tanked.
Yeah, I totally agree. I mean, I think that you know, if I'm a buyer of a business, I don't want to buy into in an illegal situation, right? So any workers who aren't legally authorized to work in the United States, it's an illegal situation. That's one. Two, you're right. I mean, if I want to get them to be legal, I gotta probably help them financially to get an immigration attorney because they can't afford it themselves. Or I gotta fire them and hire somebody else. That's expensive. So I think it does reduce the overall value of the business and potentially significantly depending upon how many people you have in that fit this mold.
What have you seen? And I'm sure you've done, I know you've worked with your clients and have been part of the diligence process where you're helping them to supply the documentation. I'm sure that you've been in the past hired by a client that was acquiring someone and they asked you to review to make sure that the company you're acquiring was compliant with these different issues. What are some of the more interesting finds and issues that you've had to deal with over the years in that area?
Um, well, I mean, I think from a practical standpoint, I had a couple situations where people were selling equipment like trucks or machines, and they represented to the buyer that the machines or trucks or vehicles were in a good operating condition, and they they had maintenance records, but um, you know, the buyers wanted to have them inspected, and they have them inspected, and they're not what they purported to be, right?
Hmm.
So that dramatically affected the buyer's willingness to pay the price that the sellers were seeking. And I think if the sellers had done a better job of maintaining the machines or the equipment or the trucks, or maybe had upgraded in certain areas, the value of the business for sale would have escalated exponentially. Um, so so I think another item to check off the list as you're going toward a potential sale is, what have you done to repair or inspect or maintain your equipment?
Here's one that is a touchy one. And it's debated all the time, and it's very it's really depending on the owner, it could go both ways. When should you start having conversation with your employees that the company may be in a process of being sold? I've had some people say, don't say anything until the day after the sale, and others saying no. uh, they're part. They've been part of our success. They should be involved and understand what's going on. And so that's both ends of the spectrums. How do you have these conversations with your clients with that respect?
So I think there's some multiple different factors that you take into account as to the timing of this. So first, if it's a stock sale or an asset sale. So if the employees are going to get carried over to the new entity, I would uh, I would probably tell them a little earlier than if they're getting terminated in an asset sale. Um,
Can you clarify that when you say terminate assets, does it mean that everyone loses their job, or what does that technically mean?
so
Practically,
yeah,
technically and practically.
so in an asset sale, the the seller, the business seller, they terminate everybody. So they most of the employees are at will, meaning you can terminate somebody with no notice. So they get everybody gets fired. Now that some of them may get rehired, all of them may get rehired by the buyer of the assets, but they don't have to be. So there's no guarantee of a job for those workers, and they can go on unemployment for a period of time while they try to find a new job. So so I don't know that I would give them a ton of notice, because especially if they're at will, because I don't want them just leaving before I've got the business ready to transition. If they leave too early, I might not be able to get it in shape for the closing. So I need to figure out what's an ideal time to get rid of everybody and still hit my closing and be ready at that time to sell. Part of that process, though, is if I have employment contracts with anybody, I need to look at, well, are they at will employment contracts, or are they notice contracts? Some contracts say that I have to give a certain amount of notice to a certain employee. So I need to make sure I'm giving that notice, or I'm buying into a breach of contract claim.
Mhm.
So I might have to tell some employees earlier than others that I'm selling, and that they're going to be terminated. I would try to figure out if that employee who's got a notice in their contract is going to be hired by the new, or at least offered a job, so that I can have a conversation with them where I say, okay, I'm telling you because you got this provision, but we're not telling everybody else. You're in line to get a job offer from these people. That try to cushion that blow a little bit. With a stock sale, um, if everybody's just transitioning over, I might want to have a meeting where I tell everybody, introduce them to the new potential owner, have the new owner kind of give them a sense for how great things are going to be under their new business and what they're going to be offering, and try to make it a real positive message that,
Mhm.
hey, this is going to be great for everybody, right? And then and that can happen, maybe a little earlier than the at-will termination in an asset uh, purchase, but at a time when what the deal's going to go through, the new business is ready to make that kind of a speech, and everybody's ready to sort of say how great this transition is going to be for people.
I've seen, and this is just my like observations, is I find it there's definitely the balancing act you're talking about is letting the employee know, but making sure that you, particularly, let's assume like most of the transactions I work on, the employees are all staying. There might be an overhead person or two that might be at risk, but for the most part, if you're buying a services company or construction company, uh, a technology company, you're buying the people who are supporting that product and that service. So let's assume they're all coming over. The balancing I have is like letting people know, but also having the roadmap of what's going to actually happen after the close. Who are they going to report to? Do the benefits change? Will the compensation policies change? Um, will the vacation policies change? Will their 401ks change? Like so, tell me if you agree or disagree or any modifications you would propose. I typically like to see until you both sides agree on what the message is, like what as a seller, I'm going to tell my employees this is why I'm making this sale. Here's what's going to happen. The buyer can then say, yep, that's exactly what we're going to do. Here's where things are going to be the same. Here, things will maybe be slightly different. Here, things are going to be definitely better. But you have a coordinated communication plan. And until then, I find it's very difficult to have those conversations unless they are directly involved in the transaction, helping the thing get closed. How do you see that as that balancing act?
Yeah, well, I think it's in both companies' interest to have a unified message and a positive message for those employees that are going to be transitioning to the new entity. So I agree with you. I don't think that you can have a disjointed message and have a smooth transition. So if you um, and if the seller and the buyer get together and kind of plan it all out, they can really both benefit uh, with a unified message, and the employees will be a lot happier and at ease, and you'll have less headaches than you would if people don't have their questions answered. So a lot of times, I think you want to have some kind of a handout or a disclosure for the workers about how things are going to go at the new place on the issues that you're talking about, and and the and that can be given by the new uh, ownership uh, at a joint meeting where they're
And,
discussing the transition.
and we're getting close to the end here, so I have a couple questions, a little shorter. Um, I've heard some clients in the past in prospects like, well, that's going to be someone else's problem. If they don't find it, they don't find it. Like no harm, no foul. How often have you seen in the transactions you've been involved with where these issues weren't uncovered?
Well, it certainly happens, particularly if the buyer isn't savvy and isn't doing a good job of due diligence. Um, but the problem with that is that when they do discover it, or if they discover it, oftentimes they're trying to drag you back in to some kind of a mess. And so it's a double-edged sword. On the one hand, you you benefit by not having it revealed and maybe getting paid, but then you might have to deal with it in a year.
Yeah.
Um, So, again, I think the better practice for a business is to get ahead of it. You know, you like anything else, you invest in your business, right? You invest time and effort and money. If and that increases the value of your business. So if
Mm.
you get ahead of these problems in advance and put them right, you're going to be able to say in all good faith to the buyer, we got these things under control, and they'll pay, presumably fair value for a business that's in good order.
Yeah,
So I would rather you did that than just try to hope that you can slide by and they don't catch you.
I would agree that. And what I've seen is when a company is well run, well organized, the policies and procedures across the board, whether it's employment or not, are well documented. You can see that they're being followed. It just leads to credibility throughout the process. It reduces any last second adjustments or indemnification issues related to potential liabilities, that you get more value and you get more cash at close by doing it right. And it just gives that, and I think it's because it gives confidence to the buyer that there's less issues so that they're willing to pay more. Seems less risky. So the less risky a business is, the more valuable it's worth.
Yeah, and I think that the process goes smoother and quicker,
Yes.
less headaches, less stress. If you're selling, you want to get it done and get out.
Yeah.
And if things a mess, it's going to take a long time, and you might not get to a sale. So,
I think that's a great, and we'll probably end on that point. I think it's a great point because then one of the other issues I always hear from clients is, why is it taking so long? It's like, I wanted to go faster. I'm like, well, you had this immigration issue. You had this labor wage act violation. You had this classification issue we had to resolve. So you had all these different issues that weren't big in your mind, but they need to be resolved and documented before we move forward. And so that slows the whole process down. So if you want to get in and out quickly, like you said, and I think that's a dead on, have everything documented ahead of time so that when you make your decision, you're going from offer to diligence to close in the most timely manner and fashion. Tim, thanks so much for your thoughts and your wisdom. And I know I rely on you a lot, so I appreciate you sharing it with the listeners of the podcast. If someone wanted to get a hold of you after this to help them through this process and think through this process, how would they get a hold of you?
so the best way to reach me is my email is tim@foleylawpractice.com, or they could call our main office line, which is 508-548-4888, and ask for me. Um, and we do a lot of this kind of work that I've been talking about, the audits and such, getting people's businesses in order. So if people do have questions about those types of audits or correcting situations that they think are not in great shape, that's the type of work we do every day.
Excellent. Thanks, Tim. I really appreciate it. Again, you've been a resource for me for a long time. Hopefully, this has been helpful for the listeners, and I look forward to collaborating with you on more projects.
Thanks, Greg. I really appreciate you having me on. It's been great.